Hello and welcome to the Priggya Arora Show, where we discuss law and entrepreneurship with people who have been there and done that. My name is Priggya Arora, founder of PL Legal, an intellectual property law firm. And our guest for today is someone who believes in exponential value of invention, Mr. David Hurtado. He's the founder of License Art. So hi, David, welcome on the show.
Hey, Priggya, thank you very much. And I am very happy to be here and to talk and share my experience, my knowledge if somebody can help with that.
Thank you so much, David. And we'll start with something very fun, which is our warm-up question. What is one thing in life you cannot live without?
Oh, difficult question, but I think I would like to move always to do projects every time. I think the retirement for a young retirement, for instance, is not an option for me. I need to do projects professionally or in sports or any kind of projects.
Wow. So David, can you say you cannot live without work? So probably.
Yes, it's something that is not good for some people, but I think when you work in things that you are passionate, it's not like a work. It's more like
and I think entrepreneurs live with passion and they feel that passion, like we can't live without work.
Yes, I think this is the most important thing, to be passionate about your work. If you are an entrepreneur,
get a job, it will be better and you can get better results.
Okay, great. So David, can you share your life story in short? Like, how did you develop your interest in innovation and why did you choose this field?
Well, I have been always curious for technology, for creating new things. And when I started in the university, my background is biomedical engineer, and there was a project to develop ergonomic lab tray for wheelchair users. I started with that project, and in that time, when I was young, in 2006, 2008 maybe, a law firm knocked the door of the university. The university, they didn't have any patents yet in the moment. They started to do invention research in the projects, and they found 4 projects. One of them was my project as a student. The other project were from professional researchers. The law firm said to the university, to the research department, that the easiest and the most advanced invention, and the easy because it was a mechanical product, was my invention to file a patent and to get the first patents. So they analyzed the product and they found two inventions, one for the lab tray and the second one for a special hinge.
Wow.
That's it. They drafted the patent. I am honored to be the first inventor of the 2 patents in my university, in my hometown. Yeah. So in that moment, I started to know more about the world of the patents, how the patents can improve the innovation process, and how can I create a startup based on the intellectual property. Wow. To do the story short, I built the startup, I licensed the patents, I went to US, to Pittsburgh University, we improved the product, we built another patent. In 2018, after receiving a grant from the Colombian state, and tried to sell the product in US and build the first batch of 200 lab trays with injection molds that it was a big investment, we broke. So it was a very good master PhD postdoc experience in entrepreneurship. And now this whole story, my master in patent law in Israel, my previous work in a law firm, and my last one in a university as a director in innovation and entrepreneurship, gave me all the tools to analyze and to see the invention as the tree, as a triangle, with intellectual property, with technology, and with business model. And right now, this is licensed art. It's all the 10 years, 15 years, if I count the starting of the project, talking, thinking about innovation and how the patents can be good, not only for entrepreneurs, but also for countries and even for continents.
Correct. Absolutely amazing. It's so interesting to know that you started with a project which was related to engineering and not related to law, and you eventually went onto the field of intellectual property and analyzing how patents work, and you started building your career in this field. Very, very interesting to know this.
Yeah, something that I always tell to the people at the first time they say, okay, you're a lawyer. No. My background is engineer. After that, I studied a law, a master, thanks to the WIPO, World Intellectual Property Organization, and a scholarship that they say, we are looking for people from developing countries and from technical side that have some experience in patents.
Correct.
So for that reason, my view is quite different to some law firms, or my approach is quite different.
Correct, absolutely. And for people who do not know about World Intellectual Property Organization, which is WIPO, it is an organization which is the main organization for the field of intellectual property. And if you are looking for starting a career in this field, they have they have many courses available on their website. You can go and check out them.
Yes, free courses, other courses that are very cheap, and
Correct.
also scholarships for master if you would like to have a career in intellectual property.
Correct, absolutely. So, David, you mentioned the term overclocking your inventions, because your title is very, very exciting. Overclock your inventions and uncover their exponential value. So, can you tell us what do you mean by overclocking the inventions?
Sure, happy to ask. Overclock is a concept that came from a computer, the computer hardware. When you accelerate the clock of your processor to increase the frequency to send information to computer, you can do your computer faster with the same components that they have. Well, if you overclock your computer so much, you can damage the computer, so you can do not slowly. But the idea behind the overclock is telling the inventors, especially from Latin America right now, but we are trying to expand our services to Canada too, is that we will overclock your inventions. It means we will accelerate or over accelerate more than the acceleration.
Wow.
So it is the derivative of the acceleration, second derivative of velocity, and third derivative of distance. We will do this process very fast, with the same components that we have, with the same people, with the same entrepreneurs, with the same ecosystem, with the same tools that we have. So this is the concept behind. We will do very fast using smart technologies, using the knowledge of the triangle that I said before, business, engineering, and intellectual property, and using the crowd knowledge that we can find in social networks, especially for us in LinkedIn, where you can find a lot of professionals that we can contact and have a feedback from them. So in that sense, our idea is to reach the product market fit, that is the growing stage from for startups, that in the literature you can see that it's like 2 years for digital startups. For science-based can be 5 years or maybe 10 years. And we would like to over-accelerate this process in 3 months, 6 months, or 1 year, depends on the kind of invention. For that reason, I liked it to use this jargon word that is overclock.
Wow, awesome. I'm just amazed by the analogy you just gave, like distance to velocity to acceleration, and then what overclocking means, and which is related to innovation. So I love the terminologies you use and the way you explain them, that why are you using those terminologies. Very, very amazing.
Thank you.
Yeah.
Yeah, I mean, I'm a geek guy also. I'm a technical guy. So I would like to talk with, well, especially when I talk with research with a high profile, they just talk about science, about technical things. So they always say that they don't like to work with lawyers, because the lawyers talk in a different language.
Yeah.
So I am able, or in my career, I'm trying to understand technical science, but also talk easily with a lawyer, and also talk with a business person. So this is the I think the major skill that I have developed in the years.
And I think for the field of intellectual property, this is the most important skill. Like I also say that especially if we are working in the field of patents, we might be using 80% of the technology understanding and only 20% of law, because at the end of the day, it is technology on which we are applying the law.
Sure, especially when you're talking about intellectual property based on technology, you need to understand both. I mean, there is some attorneys that are specialized in law that are very good in litigations, in patent drafting, and we need the people to work together with licensed art, with the inventors. But if you are the person that connect the inventors, the needs, the pains that they have with the pains from the customers, you need to have this skill to understand both sides.
Absolutely. So, David, can you share, I think, maybe 2 questions which are frequently asked by inventors when they first meet you? I'm sure that there would be many, but just 2 which are on top of your mind.
Well, maybe not. The first one that I want to tell you is not a question. Maybe it's an expression that they say with my students, especially when I do classes or inventors, they say, and that thing was patentable? And I say, yes. So many things, the invention that they developed, or when I show some patents for the samples, I say, okay, we can analyze this invention, you can see this patent, you can see the claims that are the legal sentences. They always surprise for the easiest way to protect an invention. And the second thing that they say, okay, if it is quite easy, because it is not easy, it's easy maybe for us that we are looking for many alternative patents. If it is that easy to file a patent, why don't we have a lot of patents? Why cannot file my invention? And this is a question that I cannot answer. I don't know why, because legally you can find the way to get a patent, even though with a string or with a limited scope.
Correct.
If the invention is very strong and the invention doesn't have a prior art, we can get a broad scope of the patent and protect some design around, and we can have a very good patent. But legally, it's easy to file a patent and maybe to get a patent. It's like the same to open a company in a city. It's quite easy to go to the authorities to say, give me the company, this is the name, and that's it, you have the paper. But the difficult part is that invention is useful for somebody, and that people is willing to pay the amount of money to maintain a patent protection, because if not, please sell the products and innovate, competing with your competitors and trying to improve your products. But if you see that the market is huge, that there is an emerging market, and you can see that a lot of people can use your product or your service once per week, and you can reach more than 1 million, 30 million, 1,000 million people with your invention, please file a patent, because you have the best way to protect is a patent.
Very rightly said. I think if you have utility in any technology you develop, you must just, without thinking, go ahead and file a patent for it. At least you'll be able to stop others from manufacturing the same product. So if you find that there is a utility in your product, you should not think twice and go ahead and file patents.
Well, I would like to add something that I am working right now with a lot of entrepreneurs from the software industry. Yeah. And there is a powerful intellectual property that is quite new for entrepreneurs, but for Microsoft, Qualcomm, Tinder, they are very useful. That is a design patent.
Correct. Absolutely.
So I always teach to them that with design patent, we can protect the interface that you are using for your software. And I always show the example for Airbnb, Tinder, Apple, that win a battle against Samsung using patent design, patent design with animation too. So if a software company or startup are developing a very nice interface, and maybe the animation, it will be the core of your invention, we need to think about the design pattern.
Absolutely. So see, whenever there is a user interface, you would not want the same color combination, the same options, and same experience which user gets from your app or your software to be given by somebody else. So it is very, very important, as David said, that whenever there is anything you have developed from the interface point of view, you can go ahead and file design patents. Actually, what will happen is nobody will, be able to copy the exact interface that you are providing. That, and I think, David, that is the reason that probably we have so many marketplaces, like we have eBay, we have Amazon, but both of them looks very, very different because they cannot copy each other's interface.
Mm-hmm. Yes, absolutely. There is also another question that I heard frequently is why, if they have a patent, for instance, Amazon, eBay, and we see similar functionality in the other website, what is that? What is happening? So it's always important to say that if you have a patent, you have the right to do or to ask for infringement to other people. If you don't use your right, nobody will do that for you.
Correct.
So in some cases, a company with a patent can see a competitor that is not so dangerous for the market right now. So they can say, okay, we can wait until the moment we can see some risk from them, and we can ask for to license or to stop to using some functionality, and after that they can file the lawsuit. So this is important to know because the patents can live in the same ecosystem.
Correct.
Even they can something that we call the freedom to operate. Maybe I can have one patent and the other can have also the patent, but maybe this patent cannot have the freedom to operate with the other because maybe the other patent can have something that infringe the patents, but they can live together in the same ecosystem. So this is useful when we see the risk of the competitor to take you the market. So this is the tool or your shell to battle with the other company.
Correct. And David, I would like to add here, like whenever people are launching a product, for example, in one country, then it is very important to do a freedom to operate search there, because maybe it is a possibility that the competitor hasn't filed the patent application in that country. And if the competitor hasn't filed the patent application in that country, then you are free to operate there without worrying about infringement suit. So I think that is also a good strategy. Like when people are launching products, they can check like which are the countries where our competitors have filed the patents, which are the countries where the patents do not exist, and if they do not exist, is there a market? If there is a market, then probably we can go and file the patent there.
Sure.
Yeah. So yeah, so now coming to our rapid fire round, I think we'll just start with the rapid fire round very, very quickly. So David, what are this is called a 3-2-1 rapid fire round, and please answer these questions very quickly. So what are three things in life you are grateful for?
Well, for all my experience in life, for a lot of traveling that I have done, and my career. I'm happy with this career.
Wow. Experience, traveling, and career. 2 traits you think are useful for your career?
Well, I really don't know. Traits
or habits, whatever you think are useful for anybody who is working in the same field.
I think to be open to your client necessity, is very important because sometimes I have seen some lawyers that draft the patent without the main goal that the client needs. So it's very important. I love this quote that says, "Lot for the problem, not for the solution." Wow. So doing the solution is quite easy. Create new things is quite easy, but if you understand and love the problem, you can do a solution that is useful for somebody and can pay for that.
So I think understand your clients and understand the problems around you.
Yeah, love for your problems, not only understand, try to be intensive with your problems.
Wow. And one aspiration you have for the future?
Well, I said in the Latin Startup Conference in Toronto 50 days ago, I think, that I love how the Canadians, when they do a speech, they talk in English and in French, because those are the two languages in Canada. They have two languages, main languages in Canada. One of my belief is that whole Latin America, and when a lot of people asking me which are the countries from Latin America is from Mexico, in North America, all Central America, Cuba, Salvador, Guatemala, Panama, and all South America. We are the same passion. We are our culture is quite the same, so we have a lot of similarities. So I would like to do a speech in Spanish and in Portuguese. Wow. Because those are the main languages that we have in Latin America. And if we would like to join the people in our countries as a main force, similar to European Union, we need to speak both languages. I said that my next speech will be in Spanish and in Portuguese. I don't know any word in Portuguese. So my next challenge will be learn Portuguese and do the speech in both languages.
Wow, that's a big goal, but I hope you all get a status. Like, I am also very jealous with European Union, the way they have like EPO set up. And I also sometimes feel like for Asia, we should have something like that, so that in each country, we do not have to go and file patent application. At least we can come to that consonance. But let's see. I think similar kind of things we all preach in our jurisdictions and the area around us.
It will be very good also for Latin American countries. We have the same law, patent law, in the Andean community. It means in Peru, Ecuador, Colombia, Bolivia, well, Venezuela was there, but right now, no. We have the same patent law, but we don't have one application for all the countries as European Patent Organization. And I think it would be a very good political movement in order to increase the innovation for our countries. If we can have a similar unitary patents, or at least unitary application, it will be useful for our innovations.
Wow, awesome. I just hope that your dream comes true.
Yeah, I like it.
Yeah. And David, so can you share some key takeaways for our young lawyers and legal entrepreneurs, or anyone who want to start working in the field of intellectual property?
Sure. I think that we are living in a very interesting days. Yeah. Where the law industry has a lot of potential using the the new technologies as blockchain, as metaverse, as artificial intelligence. And I think that the law industry has a lot of potential to do many applications that we have never seen.
Yeah.
When I seen some startups, I am seeing the same problems with an improvements solutions.
Yeah.
What about to see other problems that maybe we don't know that exists right now, and start to doing a solution for the future? For instance, in metaverse, I saw a webinar when they say, okay, when you are in the metaverse, you don't know if you are talking with a person or artificial intelligence avatar. So you can configure the avatar to do the initial negotiation for a dispute resolution, for a technology transfer, for any kind of negotiation. And when the negotiation or the deal is near to close, you can enter in the avatar and finish the negotiation. So I said to me, wow, this is the future.
Yes.
But when we talk about, in my country, when we talk about the iPhone as the future, we say that 4, 5, 6 years ago. And right now, every person we can see with an iPhone. So it's not so far. Maybe it will be 2, 3, 4 years, maybe for long, when we can have this kind of applications. And I think that if you are in a law industry, or if you are a law entrepreneur, or if you are a law student, even though if you are not in the law industry, if you are an engineer, if you are a software developer, I think it would be a very good opportunity in this industry.
Yeah, absolutely. All the high-tech domain, I just love them. And what happens is technology develops, and I think law is somewhere which catches up and catches up. Law is somewhere lags behind the technology. We are not ahead of the technology.
I think this is an opportunity, because if you don't have the pressure of law, you can create new things. And when the law came, so you need to restrict a little bit, but you can push the law in order to create a new world.
I think it gives a lot of space to experiment, just a lot of space to experiment.
Yes, yes.
So with this, David, thank you so much for your time and for your willingness to share. I'm sure the audience is going to love this episode. Thank you.
No, thank you. Thank you very much for the invitation, and happy to share the experience, not only in Latin America, in Spanish, in India, and everywhere, because this is the new world that the pandemic teaches us. And I always wanted to say to people that in Latin America, we have very good technologies that the people have never seen, and maybe we can have here the cures for some disease in the world. So I invite everybody to see new technologies, very good negotiation and prices in Latin America, and very high level of research. And dice licenciarte or licensarte in English, licenciarte in Spanish, how to leverage the Latin American ecosystem to came from exporting commodities to delivering Latin technologies to the world. Thank you.
Awesome. And I wish you all the very best with your aim. I just feel a lot of passion here. Thank you so much. Hey there, thank you for attending today's session. If you enjoyed today's session, do follow our channel and consider sharing it with a friend. My name is Priggya Arora, daughter of inspiring parents, alumna of IIT Kharagpur, engineer turned lawyer and entrepreneur, and now founder of PA Legal, where we help creators and innovators protect their intellectual property. Thank you.